First District Court of Appeal is now in session. All who have business before this court draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Good afternoon. Be seated. We have two cases on our agenda this afternoon. We'll take them in order. The first is case number 22-4177, Palm Beach County School District et al. Versus Battle. If appellant's counsel, that's right.
Good afternoon, Your Honors, and may it please the Court. Samuel Spinner on behalf of the appellants in this case, the employer carrier Palm Beach County School District and Sedgwick. If I could please reserve 5 minutes of my time for rebuttal.
Okay.
Thank you, Mr. Chief Judge. Appellants respectfully request that this Court reverse the JCC's order on appeal granting Battle's claim for her right shoulder injury sustained in the June 6, 2022 accident because that accident occurred due to an outside agency other than Battle herself. As this Court is aware, this case essentially turns on the interpretation of Florida Statute Section 440.092, subsection 5, which addresses the limited circumstances in which a subsequent intervening accident that's not ordinarily in the course and scope of employment can entitle the claimant to recover workers' compensation benefits for that injury. This is a legal question that this Court should review de novo and therefore should not afford any deference to the JCC with respect to its interpretation of the statute.
So the JCC found that there was not an outside agency from which the accident arose. What say you is the outside agency?
Well, I think there's two approaches that the Court can take, Your Honor. The first approach comes from the plain language of the March opinion, in which this Court limited the only limitation that this Court has ever placed on the term outside agency is that it cannot be the claimant himself or herself. And so implicit in that is that there must be some other reason that the accident occurred other than the claimant's own actions. And as this Court recognized in the Prater...
So does this take unwinding what was the cause of the accident here? Was it a stick? Was it a rock? Was it just bad driving?
I think that it does require some... the legal interpretation is the legal question of the statute. The factual issue is based on the testimony as to how the accident occurred. And so to the extent we believe that the JCC misinterpreted the statute and how it applied it in this case, that is the legal problem. We don't take too many issues with the JCC's findings in this case, except for one of the findings on rehearing that that Battle did not actually contact the rock or stick with her scooter. But turning to the definition of outside agency, in the March case...
So the original injury was to the claimant's foot?
Correct, Your Honor. The claimant fractured her fifth metatarsal, which is the bone on the outside of your foot that connects to the pinky toe. And so, of course, the fact that she was using a knee scooter on the date of the accident is really just what brings us into the realm of the workers' compensation system at all. Because if she had not been using some sort of ambulatory aid that had been prescribed to her in connection with that original injury, there would be absolutely no argument for why we were even before the JCC as far as...
When was the date of the accident?
The original accident, Your Honor, was March 11th, and the subsequent accident was on June 6th. And so
would you say then that the use of the knee scooter that arose from the first accident made it, and I'm going back to the statute here, the direct and natural consequence of the original injury?
Yes, Your Honor. It's what brings us into, it's what allows Battle to at least try to open the door to get before the JCC, because if Battle had just been walking, not using any aid, and say she had injured her arm previously and not her foot, and she just slipped and fell, that would just be an ordinary premises liability case for which there would be absolutely no basis to try to claim additional workers' compensation benefits. And so in the Prater case, this Court recognized that if the primary injury is in the course and scope, then all the natural consequences from that injury are compensable unless there's something that breaks the chain in causation. And what the statute says is that when there's a subsequent intervening act or subsequent intervening accident due to an outside agency, that's what breaks the chain of causation, because the claimant's right shoulder rotator cuff is not a natural consequence of the fact that she fractured her foot. It's just that it put her on a knee scooter and then she fell off the scooter. But we still have to look at how that accident actually occurred. And in this case, the evidence shows that the claimant was at the VA clinic to take her fiance for his medical appointment.
And so is your argument only having to do with the outside agency part, and you have no problem with the scooter, because it involved a scooter, it being a direct and natural consequence of the original injury?
I think that's correct, Your Honor, because there's no dispute she was using the scooter. There's no dispute that she had the scooter as part of her original accident. But it doesn't mean that any accident whatsoever in perpetuity thereafter means that it falls within the workers' compensation system. And I think that's what this statute recognizes, is that sometimes you have intervening accidents caused by an outside agency, and the statute prescribes the limited circumstances in which...
What would, in your estimation, be an example of a subsequent accident that would be covered as a workers' comp injury, even though it was totally unrelated to the original injury?
Yes, Your Honor. So the first one would be under the plain language of the statute, where it says unless the claimant is driving to or from a medical appointment. And so the statute already contains that basis for compensation, which recognizes that if the claimant has to drive to or from a medical appointment and they're in usually a car accident, I think is what the statute presupposes, then it's providing an exception to the fact that that would ordinarily not be something within the course and scope.
But outside of that example, I'm sort of asking you to make your opponent's argument in a sense, but to help draw a contrast, what would be covered if she were on the scooter in another circumstance?
If the reason that the accident occurred was solely because she was on the knee scooter and it didn't involve any other conditions being the proximate cause of the accident, then I would agree. And that's what we had in the March case, Your Honor, because in March, the claimant, he had a foot injury. He was prescribed a fiberglass cast. I don't know if you're prescribed a cast, but he was given a cast. He was also given crutches, and he fell in his own home because he tripped over himself and fell down the stairs. And this court said that the claimant themselves can't be an outside agency. And so when the accident happens solely due to the claimant's own actions and not because of any other outside agency or condition or something that breaks that causal chain, that's when it's covered.
So you're drawing a distinction between if she would have just caught the edge of the sidewalk and tumbled versus there being a stick on the sidewalk that may have played a role.
Yes, Your Honor, and I think part of the reason for that is that perhaps the legislature recognized that in a circumstance where your injury is caused by the act of another condition, that you may have a basis for recovery outside the workers' compensation system. And so the claimant in March didn't have anybody to go after for that accident. He fell solely because of his original injury and the awkward way he had to walk while descending the stairs. But if the claimant in March had gone to a supermarket and had slipped and fallen on a transitory foreign substance on the ground, then that would not have been an accident within the course and scope, and it wouldn't have fallen under the statute, and it would have been a premises liability claim.
Do we know anything about the nature of the stick? I mean, this wasn't a thrown stick. This was just a stick that was laying on the ground that drivers of, I guess, anything, cars, bikes, scooters, have to just negotiate in the course of just being a driver.
Well, this was not in the road, Your Honor. It was on the direct path of ingress into a medical facility, and that's why we've emphasized in our briefs that any premises owner has a legal duty to make the path of ingress into their premises reasonably accessible. And we're talking about a VA clinic that treats wounded veterans. It's certainly foreseeable that people are going to be coming into their facility with the use of ambulatory aids.
Well, do we know anything about the stick? I mean, was this a twig or was this like a branch?
That part was not clear from the record, Your Honor. What we know is that she encountered a stick and a rock, which lends itself to the finding that there was just debris in the path of her ingress into the facility, and for someone who wasn't using an aid, that may have presented no issue. I mean, someone not using an aid could have followed those conditions too. But
And in your argument, it doesn't matter whether she fell avoiding the stick in the rock or hitting the stick in the rock, correct?
No, I don't think it does, Your Honor, because if you're driving down the road and you're following a pickup truck and a sofa falls out of the pickup truck and you swerve to avoid it and you hit the median, the notion that the couch in the pickup truck didn't cause your accident it's not logical.
But isn't that different? I mean, there's debris in the road every time you get in the car, and a driver needs to negotiate that, and if the driver doesn't, the driver's, essentially negligent, unless it's kind of an active, hurling, dynamic type situation. I mean, those are different.
Well, premises liability cases, there's several that involve someone tripping on some sort of condition or transitory condition, and this wasn't in the road. This is on the path into the facility directly from the handicap spot inside. And so businesses have a legal duty to make sure that those paths are free of obstructions, which includes rocks and sticks of things of that nature, because even if she wasn't using a knee scooter, it's possible that someone could trip and fall or become injured because of that. And that's why the law has long recognized the legal duty to create that safe path of ingress.
So
Now
your
returning-
argument, go ahead. I'm
Now,
sorry.
returning to the language of the statute, the legislature chose a specific phrase, outside agency, and earlier you were talking about, an outside condition. Well, they didn't use the word condition, they used agency. So again, what do we look to? How do we interpret that? The JCC here, I think, cited a website about professional golf rules to define, outside agency. What do we look to in reading this? They didn't say outside condition, they used agency. And what does that mean in the context of Chapter 440?
Our position, Your Honor, is that in the context of the statute, it means something, either some sort of condition or some sort of reason that explains why the claimant was injured that broke the chain of causation. And that's really what the statute does, is it talks about an intervening accident that was caused by something other than the claimant themselves.
But agency sort of connotates willfulness, correct? It seems that agency could be interpreted to mean a third party was involved. If she were pushed over by a criminal or negligent act by a third party, that would obviously be an outside agency. But
I would
a
agree with
condition is not really an agency, is it?
I think it is in this context, but it's also important to not miss the forest for the trees, in that it's not just the conditions, it's that there's a party not in this case, who's responsible for those conditions being there when they should.
Your outside agency is the VA.
I think that.
Is that right? In other
court-
words, her claim is against the VA.
If the court were not inclined to find that the condition itself can be an outside agency, then I think it's clear that the third party who's responsible for not having those conditions on its premises is an outside agency, in the same way that in the Prater case, the police officer who rear-ended the claimant was an outside agency. It's some sort of intervening act by someone other than the claimant who injures the claimant, and for that reason, the claimant has an ability to recover compensation outside the workers' compensation system. And I think that's the reason that the legislature drafted this statute, because it's important to keep in mind that this was not at school, this was not at her job, this was not in the course and scope, and that's what you need to get into the workers' compensation system. This statute creates a limited exception to the course and scope rule and says that if you're subsequently injured and it's just a natural consequence of your original injury, that's covered. If you're injured due to the act of another or some condition, you're not able to recover, and I think perhaps implicit in that is the notion that you would be able to potentially make a claim against the party responsible for your injuries such that it shouldn't be brought against the workers' compensation carrier. And I think that's exactly what we have in this case, because there was nothing preventing Battle from making a claim against the VA. Whether that claim would have resulted in money in her favor is obviously something that we can't really speculate about. But I think that's what the legislature intended with this statute, is that there's some reason that this person was injured that's not just it's not purely a natural consequence of the original injury, like the claimant in March who just tripped over his own feet, but rather because of these conditions.
Why aren't the stairs in March like the stick in this case? I mean, stairs are an impediment of some sort. People fall down stairs, regularly. Why isn't that case answer this case?
Well, Mr. Chief Judge, if the claimant in March had tripped on a third party's premises because the stairs were defective or there was a transitory substance on the stairs, then we would have been more like our case and much unlike that case. And in that case, the claimant tripped inside his own home. So there was no other person to blame. There was no other person or entity or anything through which he could potentially recover. He didn't trip and fall on a third party's premises due to dangerous conditions being in his direct path into a medical facility. And that's what this court recognized in March, is that the claimant's tripping over himself solely because of his use of the crutches is different from someone tripping over a condition or getting hit by a car like in Prater. And that's what takes us outside of being purely the claimant's actions and getting to actions that are caused by someone else, that break the chain of causation.
So it's too simple to view this as use of a device plus obstacle equals the March case.
I think that's a fair interpretation, Your Honor. If March had been at a friend's house and the friend's child had left something on the stairs and he had tripped and fallen on that, I think it would be a different case. And that's what this statute recognizes, is that injuries that are a direct, completely natural cause from the original injury are covered, but when there's a break in the chain of causation due to the act of another or some sort of outside agency, that's what cuts you off from the workers' compensation system, because it's not a natural consequence that because you have a knee scooter, she fell. She admitted that she fell solely because these conditions that she encountered in her way. And for that reason, this case falls under the statute in that it was caused by an outside agency. She was not in the course and scope, and she was not driving to or from a medical appointment. And for that reason, this court should distinguish March based on those facts, apply the statute in this case, and reverse the JCC's order, and I'll reserve the remainder of my time for rebuttal.
Thank you.
Mr. Schwartz. Good afternoon. May it please the Court. Ken Schwartz on behalf of the claimant, Carissa Battle. I'm here for oral argument. Kimberly Hill wrote the briefs. At this point, my introduction was largely covered by the Court. There were a lot of issues that I wanted to bring up, but the one thing that I didn't hear the Court get into that I think is critical here is that the defense in this case brought up this issue in the trial memorandum for the first time. This is not something that was tried by consent. This was an issue that could have been brought at the pretrial stage, and the 60Q rules that control this issue mandate that if there is a claim or a defense and you have the opportunity to bring it up in the pretrial stipulation and you don't, unless the judge of compensation claims finds good cause, then that claim or defense is waived. There is no finding here by the JCC that there was any good cause, and the claimant submits that the issue was waived, and that should be dispositive of the entire reason why we're here today. The JCC did not find that there's any basis for the well, I'm not going to beat the dead horse. So the reply brief by the employer carrier submits that this was tried by consent, and the claimant would argue in response that it could not have been tried by consent because the evidence was already presented. This wasn't a matter where there was separate evidence that could have been considered and it was introduced at the final hearing and then the claimant stayed silent on the matter. There's no implied waiver of an objection to try an issue by consent where the evidence was already introduced into the record, and that's the case here. So the claimant submits that that would be dispositive of the issue, and there should be no interpretation as to what an outside agency is. If we have to get into that, then I would submit that the issues brought up by the employer carrier effectively seem to ask this court for an advisory opinion as to what the statute should be interpreted to mean when looking at outside agency. A key fact that's been overlooked by the employer carrier in their presentation today and in the briefs is that there really is no dispute as to what happened with Ms. Battle, but for a couple of very minor things. So we don't have any evidence in the record in answer to one of the questions that was put here about the stick. We don't know the size. We don't know where it came from. We don't know the shape. Same thing with the rock. The rock could be big, small, could be Dwayne Johnson. We don't know. There's no evidence of any kind to say what this was, where it was placed, the nature of the obstacle that these things presented to Miss Battle. What we do know is that she had
Or
the...
whether it could have been easily rolled over. I mean, there are sticks in the road. I generally try to avoid them, but sometimes I run over them, and, you know, it's fine, particularly if it's debris. I think your brother used the word debris at some point. If it's, you know, if it's an insignificant twig of some sort, it doesn't matter really whether you swerve or not. I may choose to, and that may cause me to go off into the woods or something like that, but that causation piece and not knowing much about what kind of stick or rock we're talking about seems to enter into whether it's an outside agent and enter into that question.
I agree that it does factor in, and there's a lot of reasons why, including but not limited to what happened with Miss Battle as she approached these things. We don't know the timing of when she saw them. We don't know how close she was to them. We don't know whether it would have been avoidable had the scooter been in perfect shape and sized appropriately for her and a more substantial unit than the one that she had. We don't know any of these things because it's not clear from the record. But we do have sufficient evidence for the JCC to have made his findings that she did attempt to avoid these things in the path. And there's evidence in the form of the opinion from Dr. Suarez, who said it was at least 51% of the reason why she fell. That's sufficient to warrant affirmance.
I don't think there's a real dispute, unless I'm missing something, that I don't think your opposing counsel really argues, at least as I understand it today anyway, that it matters whether she was avoiding the obstacles or she hit the obstacles. Either way, maybe you could address what I hear as the essential argument that we have to interpret this sort of in a premises liability manner. If the VA was negligent in keeping its sidewalk clear, then it's an outside agency. I mean, I don't think anybody's really arguing that your client was at fault in any way, and that there wasn't a good reason to avoid the obstacles or whether she hit them. As I read her testimony, she wasn't sure whether she hit them or she avoided them. But tell us why that's not an outside agency, assuming we get past the preservation.
Why are the stick in the rock or her attempt to swerve away from it?
Right. Why a
agency?
condition like that is whether she's avoiding it and falls, whether she hits it and falls. Why is that not an outside agency?
Well, I think your question informs my answer, which was why is there no? Doesn't an agency require some sort of? You started the word with the C. Consent, I think is what you said.
Willfulness.
Willfulness. Thank you.
Yeah, it connotates an action, I think.
Right. Under normal, I guess, big picture terms, we have agency as an area of law. Well, agency requires consent. It requires volition. It is the transfer of a fiduciary obligation from one to another. That obviously requires there to be some greater intellectual capacity than a stick or a rock. So I'd say if we're looking at the plain language of the statute, agency, whether inside, outside,
Like if she was attacked by, if she was attacked by an assailant, you would concede that would not be a workers' compensation injury.
Well, no, and in fact, the Bouillard case that the court recently ruled on involved a person who was attacked by an outside agent, and
right.
Obviously the claimant contends that should be compensable.
No, that was in course and scope, though. But in this situation where it's totally unrelated to the original accident, if she had been attacked by an assailant after escorting her husband or to the VA, that would not be covered under the statute, correct?
If there were no imported risk or anything along those lines, then yes.
Right.
If it was just an ordinary person walking along minding his or her own
that
business,
would be an outside agency.
That could be considered an outside agency, yes, unless that the person was perhaps in the course of going to or from an authorized medical
Whereas if
appointment.
the sidewalk were littered with foot-wide boulders and trash and debris and branches, maybe a hurricane had just come through the area, and she attempted to maneuver that and fell down, your argument is that cannot be an outside agency, right? That has to be your argument.
I'm always reluctant to answer, always and never right off the bat to agree, but I'm inclined to agree with that, yes. I don't see...
And whether she falls avoiding all that obstacle or she hits the obstacle is irrelevant, in your view.
Whether she hits it or whether she falls because she was attempting not to hit it, I don't think is really a relevant situation. What it would go to would be perhaps the negligence of whoever might be responsible for that stick or whatever it is being in the path. One very important thing that we don't have here is any evidence of any kind or any facts, any factual findings by the JCC or any court of competent jurisdiction to say that there was any negligence of any kind that could cut off the liability of the workers' comp carrier in this case. If there were, then it would be on the obligation of the insurance company, the workers' comp insurance company in this case, under 44039 to go pursue that if the claimant hadn't already done it on her own. There's a 1-year period pursuant to 44039-4A whereby if the claimant hasn't gone after the person who was negligent for their injuries, the third-party tortfeasor, then the opportunity
But that
shifts to the
applies
carrier.
that applies to course and scope, right?
And it would be up to the insurance company to take some steps to
I
demonstrate.
mean,
that
this
it was
is
negligent.
a very narrow applicability where an employer is required to cover a risk, assuming you prevail, on the merits, where an employer is required to cover risks totally unrelated to the original accident, other than she had to be in the scooter, of course, totally unrelated to the course and scope of the original accident. It's sort of making the employer a universal insurer in perpetuity for other accidents that can occur because she's in the scooter. So that's a fairly narrow class of coverage, right?
Well, I respectfully disagree, because we have situations like Mr. March in the opinion that was discussed by Mr. Spinner, where the claimant was at his home, and I respectfully disagree with his characterization of the facts. It doesn't say that Mr. March tripped over his own feet. It said that he was having difficulty with the stairs because he had a cast on one leg and he was using a crutch in the other. And I don't think I could maneuver stairs up and down with a crutch, whether I had a cast or not. But he didn't trip over his own feet in the words of the opinion. He had difficulty doing it. And that's similar to the facts that we have here. And so anybody who's got crutches, anybody who has a prosthesis, is in a similar situation if that prosthesis could arguably affect their perception, their balance, anything of the sort. I don't think that this would be substantially different if the person had a lower leg amputation, for example.
Right, so if you were to be granted a wish from a genie and get the written opinion, you would want the court to say an outside agency cannot be a condition. Just like the person in the cast falling on the stairs, just like your client falling from the debris, that can never be an outside agency. I think logically that has to be your argument, right?
Well, not to try to sound glib about it, but in answer to the direct question, the ideal opinion would be a procuring affirmance, because the facts here support the interpretation that the JCC made.
I'm suggesting if there is a written opinion in your favor, then that written opinion in your argument should be that a condition, a negligent condition of a third-party premises liability, whether it be extremely negligent, whether it be debris all over the sidewalk, whether they be in another situation totally liable under a premises liability suit, for this exception, that can never be an outside agency because of the word agency.
I don't think I would ask for that broad a reading of the statute, or do I think that it necessarily is required under these facts? Because, again, what we have is we have Ms. Battle, who had a very similar situation to Mr. March. And I think it's easily written in a way that says that the JCC's factual findings are supported by competent substantial
Yeah, I'm not
evidence.
sure stairs are a lot different than debris. And I'm not sure that case turns on the fact that the stairs are in his own home.
And that's another key point.
Because, in fact, he could sue his own homeowner's insurance.
Exactly.
If that's the third party. Right.
And either way, there's been no evidence in the record to suggest that anybody was negligent. That wasn't raised. First off, it wasn't raised in pre-trial. It obviously wasn't addressed at, other than argument at the final hearing, where the employer carrier said that, well, this is on the VA, and that cuts off liability. Well, we don't know that it's on the VA. There's no evidence to support that. So I would submit that the ideal opinion in favor of the claimant here.
Well, I don't think that's required. I don't think it's required that there be evidence that let's say an outside agent. The statute doesn't require evidence that the outside agent is either negligent or intentional in causing the injury, correct?
I agree. The statute doesn't say that, but the employer carrier does. So to the extent that that's their argument, I think that it's important to clarify that March still applies, that the facts of this case are consistent with March's logic and its outcome, and the judge correctly applied March below when he said that there's really no difference here. Ms. Battle was in attempting to go to use the restroom in the VA, so not on her own premises. We can identify whose premises it was, but what if we couldn't identify whose premises it was at all? If she was just out and about, she didn't know exactly where she was.
Again, logically, I don't think that matters from your perspective.
It doesn't, Your Honor.
It doesn't. It doesn't
does.
matter how negligent the third party is. It doesn't matter how horrible the conditions are. Those conditions, your argument is they cannot be an outside agency.
Our argument is there was no outside agency.
I understand that. But logically, that's your position, right?
Yes. Yes. There cannot be. Let me think about that as I continue to address
It's
other
not a
issues and come
hostile
back.
question.
You never know.
I know you never know.
You never know. So let's see, just to make sure I haven't covered everything. It was addressed in the opening that there has to be some sort of willfulness, and I would submit that the judge's position in the order below, what Judge Johnson said, was that there had to be some sort of an animate object, and I think that that's fairly consistent. There has to be some sort of, at least some action. It's just similar to a car. A car is a potentially dangerous instrumentality in the state of Florida, but not when it's sitting in a parking lot, I guess minding its own business, if you will. It needs an operator of some sort. It needs something to act on it in order to put it into motion and make it dangerous. Sticks and rocks are no different. Sidewalks, I mean, they don't move in any way, but there's no
Well,
evidence
it's a
that the
different
sidewalk...
case if it's a hurled stick or a hurled rock. That's a different.
Yes, because you have some actor of some sort putting the thing into motion. It's been created, it's become an instrument at that point. It's no longer just an inanimate object sitting idly, and somebody could potentially easily avoid it. As you said, there are times when you might decide you wish to roll over something because it's, I guess, more hassle than it's worth to go around it, or more potentially dangerous. But Ms. Battle here saw these things in her path, and for whatever reason decided it would be in her interests to try to avoid these things. There's no evidence as to whether the wheels on the scooter were particularly small or susceptible to being punctured or being thrown out of position as she maneuvered her scooter, but she made the conscious choice, and that's based on evidence in the record that the scooter itself was wobbly, that one of the doctors had told her it's not fitted properly for her. So in order to avoid these possible dangers, she chose not to roll over these things, but to move around them. They didn't jump up and act on her. She made a choice, and it didn't work out because of the nature of the device that she was required to use because of the original accident. This was the direct and natural consequence of the original accident that injured her fifth metatarsal, and there really was nothing much she could do about it. When she maneuvered the scooter in whatever way, and there's no finding that she did it negligently, her original
Essentially,
position...
you're arguing March. This was a March case. An obstacle plus a device equals.
If I had to give you an elevator pitch, yes, it would include the word March in it, because that really is what this boils down to. It's the issue was never properly raised. March applies, and there's no way to blame a third party for it. That's really as simple as it gets from the claimant's perspective. Just if you give me a moment to review, unless the court has other questions, I'd just like to check my notes before I conclude. I would like to make one comment. There was reference to the Prater case, and the question that followed was about March and why the stairs in March isn't like the instant case. And the difference with Prater is that in that case, that was the one with the police officer where there was a motor vehicle accident. The parties in Prater stipulated that the outside agent was the police officer. So again, going back to the car didn't do it. The police officer did through his actions. We don't have anything like that. So I don't think Prater can be used for anything here other than just a way to comment that the outside agency, the phrase outside agency as used in the statute, hasn't been defined. It hasn't been clarified in a way that our facts could possibly be viewed any way other than consistent with March. You asked a question that I wanted to follow up on. You asked about the specific phrase agency and what it means, and I believe the answer was something to the effect that it means something that explains why an accident happened. But that goes to an explanation that that Judge Johnson gave in his final compensation order that we're looking at today. And he said, taking it to the extreme, well, if that's the case, then you can explain things with the sun, the moon, with gravity, I think were his examples. And I think that's an important distinction. Yes, he's taking it to the extreme, but it is relevant. If you are looking for something else to blame, that's easy to find. But I don't think that you can find those things unless there is the agency in the sense that the word is normally looked at in the statute. And if you look at Chapter 440, the word agent or agency or agents, all those permutations are used many, many times, but in almost all cases it's a reference to the Agency for Healthcare Administration. That's the primary appearance. I think I counted 116 instances of the word agency in the statute, and the overwhelming majority refers to the agency, which is defined in 440.02 sub 3 and again in 441.34.1, which is the managed care section, that talks to agencies and the possessive, singular possessive. There's agent about 33 times. But as you go through each and every instance of the legislature's choice of the word agent, what they do in every single case is they identify something like the agent of the affiliated corporation. So it's a person or a designated entity. It's 440.02.15b1. In 441.85, you talk about the employer or the employer's agent having actual knowledge of an injury. Well, sticks and rocks can't have knowledge. Stairs can't have knowledge. So I can continue and bore you with all the different instances where agent and agency come into play, but in each and every single one of them, they involve a person or an entity made up of people that have the ability to form willfulness, consent, and again have fiduciary relationships as the word agency is normally used. Whether you narrow that down with inside or outside really doesn't exist anywhere other than March, and as I guess I pointed out several times, the facts in this case are consistent with the facts in March and the logic that the court applied when saying that an outside agency can be something as simple as stairs, where it wasn't the claimant who caused the accident, it just simply happened. And with the support device, which is the scooter in this case, but crutches in that case, the accident was compensable because of the way it happened. So thank you. Unless there's no further questions, the claim will rest.
Thank you.
May it please the court, I would like to address the waiver argument as I didn't get into that in my original argument. This case is a classic example of something being tried by consent because while we didn't cite the statute specifically in the pretrial memorandum or in the pretrial stip, it was cited in our memorandum. We had a full-blown hearing on this issue. Both parties addressed it on the merits, and Battle never argued that it was waived or not properly raised, which is what happened in all the cases that she cites in which a court found that the defense was not particularly raised. The entire purpose of the trial by consent doctrine is that a party should not be able to see that there's an issue like that, sit idly by, and then raise it for the first time on appeal because they have consented to that being tried. And counsel said that there was no implied consent, but in this case there was actually express consent because in response to our motion for rehearing, Battle's counsel stated, quote, there were no rulings as a result of the subject hearing that were outside of the issues presented. And so in this case, when you have a full-blown hearing, a ruling on it that doesn't reference a waiver and no objection on waiver, it's clear that this was tried by consent and not a case where we tried to ambush them with an argument that they weren't ready to address, which you can see from the final hearing transcript that this was sufficiently briefed and addressed by all the parties.
On the topic of waiver and preservation, on page 28 of the appellee's brief, they assert that your entire argument about the premises liability in the VA hospital, that none of that was raised below and that you're raising it for the first time on appeal. Can you address that, please?
I think it's really more of a natural extension of what we argued below, and we were more focused on the trees instead of the forest, perhaps, in that we were looking at talking about the conditions, but there was a party responsible for those conditions in the same way that in Prater you could say, well, the car hit the claimant, and the car is not a condition.
But below you never made the argument that VA was the agent?
I don't think it was expressly made, but it's not as if we raised a completely different argument on appeal. Like in the case they cite, a party argued that a signature was forged for the first time on appeal, where it was something that was completely outside the issues presented. I think this is more of a natural expansion of what was argued below, because it was focusing on the stick and the rock as conditions, but and especially given this court's questions today, it seems clear that Your Honors believe that the issue is more, the more relevant issue is whether a party is responsible for those conditions. There were some questions about having to be a willful act for this to be an outside agency, but premises liability is more often than not a question of inaction. It's failing to do something more than it is doing something overt. And so the failure to make a safe path of ingress and egress is the issue in this case. It doesn't matter in a premises liability case whether an employee spilled something or whether they failed to clean up something spilled by another. So
That's where we just don't know. Do we know enough? I mean, we don't know whether this was an unremarkable twig or whether this was a huge branch that had to be negotiated.
I would respectfully disagree with that, Mr. Chief Judge, because what we do know is that it was significant enough to battle such that she felt that she had to avoid them and that she wasn't safe to ride over them. And so the fact that she did not feel that her scooter could safely ride over this rock and stick is enough to show that they were dangerous enough that she felt that she had to get around them. And so while we might not have a picture of them in this case, I think it's clear that she felt that it was something that was dangerous, a dangerous condition on this premises, that she had to avoid and was not able to have an unobstructed path directly into the facility as the VA is legally required to provide. At its core, this case is an accident during a personal errand outside the course and scope, not on the employer's premises, and due to the failure of a third party to maintain its premises safely. And for those reasons, Your Honor should reverse this order and find it not compensable. Thank you, Your Honors.
Thank you, counsel. All right, the second case on our docket this afternoon is case number 22-3567, 22-3567, Gartman versus Southern Tactical Range et al. Counsel for our appellant.
May it please the court, I am Mike Chesser. I am from Okaloosa County. I have with me Ms. Tara Hagan, who is the primary architect of the briefs that you have in front of you. With your permission, I would reserve 4 minutes for rebuttal. I would finally say that we have 2 or 3 primary issues that I'd like to discuss. You may have some you want to discuss as well. I acknowledge that. At the same time, there are several other issues we've talked about in the briefs, and I would ask that you not imply that we intend to waive those items that we are not able to get to in our discussion this afternoon. I want to start with the most obvious thing that I think we've got to say and talk about, and that's the case of Kluger versus White. We've got a gun range in Okaloosa County that is 200 acres, 360 degrees, and it's right outside of my client's 80-acre farm and bedroom. We'll talk a bit more about that as I go forward. I said I'd like to start with Kluger because I think, and as I do that, I think I should say first that my process of learning through this case is to say that I go to the Florida Bill of Rights and I see that in Article 1, Section 2, every person has the right to own property and to protect that property, as it says. That same theory comes from the law of nuisance. And we all know from the cases we've seen, I think there is absolutely no disagreement that nuisance is the device by which an owner protects his rights in property. Nuisance from noise is a common law right that every owner has. I don't know that there's any disagreement about that. That noise nuisance was withdrawn from the owner's privilege of protecting himself by Chapter 823.16. Florida Statute 823.16 says simply, I'm sorry, that's a mischaracterization. It doesn't say anything simply. It says in a rather convoluted fashion that I inferred finally that it said that there is no cause of action for noise. The judge, I believe, came to the same conclusion, and we went no further in a noise pollution action. It's our position to this court that Kluger says unless the legislature gives us some kind of alternative, and unless that alternative can be relied upon by an owner to defend his rights in his property, then Kluger says you cannot do that constitutionally under Article 1, Section 21. And so far as I'm aware, there are no changes to that thought. That's why we're here. The second point I'd like to make to you is the case of Ratcliffe. You will see that case discussed in these briefs as well. One of the things that is said here, and it's pointed out in the brief, that the trial judge remarked to us, I would not want to live in that house. I wouldn't feel comfortable if my grandchildren lived in that house. But there is no bullet that has fallen on that property that we can show. And because we can't show that bullet, we don't believe a nuisance has begun. And Ratcliffe says, I'll be happy to read it for the panel if you'd like me to do that. Ratcliffe and using the language, I'm reading from page 4 in my text, but I'm not sure, 97, I think. Page 97 of Ratcliffe, and using the language threaten nuisance herein, we do not mean a mere threat to do a thing which may result in the creation of something which may be a nuisance. But we contemplate by this language the beginning of construction or the proceeding with plans, which, if consummated, will necessarily result in the creation of a public nuisance. Which then raises the question, we know that this gun range had begun. And the question then, what is a nuisance? And of course, Ratcliffe was dealing with one sort of nuisance. We're dealing with another. But what is a nuisance, and when does it begin? If the court is correct that it only begins when a bullet falls at your feet or on your property, then our nuisance hasn't begun, Ratcliffe hasn't been triggered, and we ought not be here in a claim that says that we have a nuisance intrusion into the use of our property.
So, Mr. Chesser, just to confirm my understanding, so in its February 2022 order granting partial summary judgment, it basically foreclosed the Gartman's nuisance claims against the range that were based on noise and noise pollution, correct?
Absolutely.
And it did that.
Yes.
It squarely raised a Kluger access to courts challenge as applied, and the trial court
Absolutely.
denied that.
Some
So,
of the struggle that you saw since then on my part for the next 2 or 3 or 4 months was to say to the court, there may be another way to interpret 82316. It has language that talks about changes in the gun range, and which takes me to the discussion in January of 22 when the deposition of Mr. Booth was taken. That deposition, in that deposition, Mr. Booth said that he had all the permits he needed, he was legal as he could be, although the government doesn't look at me and they don't care what I'm doing. As we proceeded with discovery, we got the deposition. First of all, we got the gun range manual, the design criteria for the gun range, which said there are surface danger zones at every side of this gun range. We got then the affidavit of Clark Vargas, whom I will submit to you may very well be the #1 expert in this country on the subject of gun range design. There was disagreement under Daubert, as you see later. I apologize, I'm running out of time and I have to hurry. But our point about the Ratcliffe case is that the court used Ratcliffe to say, you haven't yet got a nuisance, you've got only a concern. And I'm certain that it has been said that our clients are more than usually distressed about things like that, and which is kind of amazing to me because I don't know how you can be more than a little bit, I can't see how you can't be more than a little bit concerned about thinking a bullet may fall into your backyard at any moment. These people have said that right now, today, they don't want to go out in their backyard any more than the trial judge wanted to go out in the backyard of that property. Now, and so what I'm saying is, the nuisance is not a bullet. The nuisance is the distress that these people have because they can't use.
Say that again, the nuisance is not a
nuisance is not a bullet.
A bullet.
Yeah, if I had a bullet, I'd be glad. I do have one, as a matter of fact, as you will see later. There was a bullet that went into a door 0.8 of a mile away, and I attempted to amend the complaint to say, Judge, this is another example of what we've been saying. And at that point, and you will see, I brought with me the third amended, I think it was, complaint before this was ever set for trial.
And all your complaints are multifaceted. Am I right? Nuisance, there are noise nuisances, there's soil, environmental nuisances, there's air nuisances,
Thank you.
then there's this bullet nuisance.
And the nuisance of being afraid of the danger to go out in your backyard. The very nuisance of the thought that if you go in your backyard, you may be encountered by this foreign object that you had no plan for, and that you didn't build your house to receive a bullet. But the fact, and my point is, their constant distress and concern over that issue is what causes this to be a nuisance today, right now, as that gun range is operating. Not later, but now. So we think that Ratcliffe they did start the gun range. They have partially completed the gun range. We have testimony in this record that says there is a surface danger zone on every side of that gun range. We attempted to bring in a third amended complaint. The court said, no, we're not doing that. That is futile to do. And I believe, if you look at that third amended complaint, it was not. I also think it was very dangerous. I think this case is very dangerous, and the case deserves to be looked at seriously. I will say further, and I'm misreading this clock. I thought I was at 13 minutes. I have 10 minutes left, and I apologize. Let me say further, as to Ratcliffe, we believe we have shown that there is a nuisance today, not a nuisance tomorrow, and that Ratcliffe is not a case that should be used to say that our clients do not have a case that they can right now present to a court. That is our argument about nuisance today, our argument about Ratcliffe. I will say now about Clark Vargas. You saw the name in this record as our expert witness. He has 2 affidavits. I have the 2 affidavits with me. In those 2 affidavits, Clark Vargas says that he was one of those people who prepared the NRA booklet that everybody feels so constrained to feel is authoritative. I'm not sure that I shared that view, but I do share the view that Mr. Vargas prepared the booklet because his name is on the face of the booklet. Mr. Vargas says, I prepared 1,000 gun ranges in the United States. He went on to say, I'm worried about this one because this one is not built as it was designed. Now, I told you that in his first deposition, Mr. Booth said, don't worry me, I've got all the permits I need. As we continued with discovery, we learned through Mr. Vargas, and even if you were to say Mr. Vargas is not a qualified witness, we had the range design criteria in the record. That is where the surface danger zone is described.
Now, wasn't there some question that, well, first of all, Mr. Vargas had never been on the property to survey what was going on the ground, and secondly, that the design was a dynamic one, that it changed?
Well, good question, good point. He said I haven't been on the property because I haven't been permitted to go on the property, but I have drone, if that's the word, drone overflown this property all the way around it. And I've seen all I need to see to tell you that it is not built the way it was permitted. And if you look at the permit, it says you will follow the range design criteria that are submitted with the permit. Mr. Clark said they simply didn't do that they have gun ranges there, they have shooting stations not shown on those plans, they have, that he said is not the same. And under the system in Okaloosa County, Florida, one submits a request for a development order. That request is then followed, much like the condominium in South Florida that fell to the ground. It's followed by the people who build the building. When they get through building the building, the design engineer comes back and says, you have built the building as it is designed. And that for that reason, then you have a certificate in your development order. Never done in Okaloosa County. Okaloosa County even testified that this 79333 scared the heck out of everybody, that nobody wants to do anything about a gun range because they have no permission by the legislature to enter into the field of whether or not they're regulating a weapon. So they don't do anything, and they didn't do anything here. Finally, Mr. Vargas said, you're not just shooting out of this range. Your surface danger zone goes as far as 4 miles when you're shooting a 50 caliber weapon. Now, a 50 caliber weapon is set up on a raised platform, which is about 300 yards from the Gartman's back window. We have recordings that we submitted to the court of what that sounds like. It is not a pretty thing. That gun shoots across I-10. The booklet says, and Mr. Vargas says, that's an idiot thing to do. That is not a legal way to establish a gun range. That's going south. They live to the north, and they have gun stations, shooting stations, sitting in the south, pointing to the north. And he said in his affidavit, those things, every one of them fall on the Gartman property. They are in the danger zone, the surface danger zone for this gun range. All of that would lead one to the conclusion, I presume, that this thing is just in the wrong place. It shouldn't be sitting there. That we make the point that the zoning ordinance in Okaloosa County says a shooting range is a permitted use in this agricultural zone. And they are exactly right. I wish I could say that were not so. But it is. That doesn't mean it belongs there. It doesn't mean even if they do satisfy the zoning ordinance in Okaloosa County, that it's not still a nuisance. We think every footprint all over this case says that gun range is a nuisance, and every day it hurts the Gartmans. The other thing I want to say before I sit down is the Gartmans have testified in every way they could, but under oath, in their complaint, in their affidavits, in their answers to interrogatories, and said, we are concerned about this. It has hurt us physically. It's hurt us emotionally. And we've now gone through it for 4 years, and it's about taking its toll on these people. They testified that they could look out and see clouds of smoke coming across the fence, settling on their house and in their pool. They testified that we feel these shots. Now, I'd be glad to tell you we hear them, but 823.16 says I can't hear them. So there wasn't a whole lot of talk about the fact that we hear them. Couldn't be. I challenge you, though, when you stand in your backyard and you hear a gunshot, and you hear that gunshot hit a metal target somewhere, you don't have any idea where that bullet went after it hit that metal target. You don't know whether it went left or right or up or down, and you don't know where it's going to come down. And if you're standing in your backyard, you're likely not to want to do that very long. That's the kind of thing that has affected the Gartmans now for 5 years. I suggest to you that is a present today nuisance. It is one that by constitutional law and by all the developed law that I know about, they have a right to say, you're taking my property from me, and I really have to have some kind of defense. They testified in all of their documents. I know there have been...
Mr. Cheshire, I just want to tell you, you're into your rebuttal time now. You have 3 minutes left. You can use it now. You can use it on rebuttal. It's up to you.
I sometimes need all the help I can get. Thank you. And I shall sit down, and I just wanted to say they have testified, experts have testified that there are no clouds, there are no percussive effects. None of these things are really happening. We think the jury has a right to decide these things. We think we have shown that there are material genuine questions of material fact throughout this case. And the whole theory of a nuisance action is that the trier of fact has got some balancing act to do, and here they've been prevented from doing that. Thank you very much.
Thank you. Fleming?
Thank you, Your Honor. May it please the Court, Mr. Cheshire. My name is Ed Fleming. I have the privilege of representing the gun range owners, who are Robbie and Lauren Booth, and they're attending by video connection today since they live in Pensacola. Mr. Cheshire pointed out very succinctly that he was relying on Kluger versus White. I would say Kruger, and Siri corrects me every time I try to dictate and calls it Kruger as well. For the proposition that the Florida legislature could not, by enacting Florida Stats 223.16, create an affirmative defense to a private nuisance action for noise. The appellant ignores the decision that was made 6 years later, 7 years later, in the ACA versus Associated case, which the court has been submitted as a supplemental authority, a case that was referenced as negative treatment to the Siegel case, which was one of the cases that the appellant relied upon. And in that case, the Supreme Court looked at the issue of affirmative defenses versus claims versus defenses, and said they find nowhere that court had ever applied the Kluger analysis to affirmative defenses. Nor do we. Not in the 33 years since the ACA case was decided, not in the 20-something years prior to that, that occurred, have we found that. In fact,
spin that out for me a little bit. Kluger, the holding there talks in terms of the legislature abolishing a right to redress. Here, Mr. Chester's argument is they have abolished noise-related nuisance when it comes to firearms ranges. Why doesn't that come within the bounds of Kluger, the abolishment of something that a private property owner, before they could bring that claim, now they effectively can't?
Well, Judge, they could still bring a nuisance claim, and they did, and the nuisance claim continued. And they can even bring a noise nuisance claim if the elements of the affirmative defense are not shown. But here's what the ACA court said later, 7 years later after the Kluger decision was decided. And this is at the case on page, I always have trouble finding these little numbers on the cases for the pages. It's on page 14 of my Westlaw printout. But it starts with a question has arisen as to the scope of Kluger Associates Industries. An appellant strongly urges that Kluger protects both claims and defenses. It points to one sentence found in Siegel case, which is relied upon by the appellants. And the Siegel court wrote that the constitutional right of access to the court sharply restricts the imposition of financial barriers to asserting claims or defenses to the court. Ignoring the inopposite nature of context in which the statement was made, we find no other case from this court that stands for the proposition that Kluger applies to affirmative defenses. There is no doubt that what we're talking about with 823 is an affirmative defense. It's not a cause of action. It is an affirmative defense to a cause of action, and it's an affirmative defense to one part of a negligence action, i.e. noise, as it relates to gun ranges, if the elements of that affirmative defense are met. The court goes on to say, and this is...
So is the way that works tangibly, they bring a nuisance action that involves noise, and you say, no, the legislature has abolished that. That is my affirmative defense. And you're saying Kluger doesn't apply to that situation.
I'm saying that it's an affirmative defense to a cause of action. And Kluger, the Supreme Court limited Kluger to causes of action, not affirmative defenses. It goes on to say in the ACA case that not all tort actions carry with them the same elements or affirmative defenses. The legislature must have the freedom to craft causes of action to meet society's changing needs.
Mr. Fleming, reading the statute 823.16, the way it's worded, it's, a person who operates or uses a sports shooting range is not subject to an action. And the trial court here, read this statute as basically eliminating any action against the range on the basis of noise or noise pollution. So assuming that we do see the Kluger test as the operable test in this case, can you get into how you overcome that test or satisfy that test?
I could, Your Honor. First of all, there's a very, very strong overriding public policy that was announced by the court, and it was announced by the court in legislative findings in 790, and the Senate bill that was cited to by the appellates themselves address that issue. And in that Senate bill, it delineates all of the rationale for addressing 790. Now, 790 was passed 5 years after 823 was. 823 was the first bill. And 823 addressed private nuisance actions against owners of ranges under certain circumstances. Not all circumstances. They had to meet requisites such as being in compliance with any applicable noise ordinances. They had to meet requisites as being properly, allowed use, which Mr. Cheshire admits that they weren't allowed use. All of those requisites had to be met. The whole nature of an affirmative defense is confession and avoidance. You could say, okay, let's assume that noise has arisen to the level of a nuisance. And of course, that's not a given. I mean, nuisance law says that airports create noise, trucking companies create noise, crushing plants create noise. All of those things create noise. Noise in and of itself is not a nuisance, but it says, let's assume that that noise from the range arises to the level of a nuisance. We have an avoidance defense,
Well, no, it
affirmation
cuts
and
it off.
avoidance.
It makes it non-actionable. You can't bring any claim based on noise or nuisance, so it never gets out the gate. So you rely on 793.33 as demonstrating or supporting that there was an overpowering public necessity. What authority is there for us to look at a completely different statute addressing different matters that was enacted 5 years after the statute at issuing this case to kind of provide that overwhelming public
We
necessity?
briefed the cases, Your Honor, that specifically say that you can look to another statute when there's the commonality involved for public policy issues. But more importantly, let's look at the Beckman case, which the Beckman case, Beckman v. Marshall, 85, Southern Second 552, Florida Supreme Court. You look at Beckman, and you look at, and I'm looking at in particular the last page of that case, which begins with a test of permissible use of one's own land. And it says the test of the permissible use of one's own land is not whether the use or the act causes injury to his neighbor's property, or that the injury was the natural consequences, or that the act is in the nature of nuisance. But the inquiry was the act or use a reasonable exercise of the dominion which the owner of property has by virtue of his ownership over his property, having regard to all interests affected, his own and those of his neighbors, and having in view also public policy. Public policy is part and parcel of the nuisance analysis. And so what do we know about public policy? As Justice Kennedy said in one of his decisions, is the legislature is the sole arbitrator of what constitutes the public policy in the state. How does the legislature state that public policy? Well, it can do so through legislative findings. What did it do here? It made legislative findings that found that gun ranges were a use that benefits the entire public. They allow for training. They allow for gun safety.
Are they talking about specific gun ranges? Because it says, and this was, I guess, 2004, the legislature finds in excess of 400 sport shooting and training ranges exist. Then it says, these ranges are widely used and enjoyed, and then it talks about these ranges again. So it seems to be talking about a group of ranges that existed in 2004.
Well, there's other cases out there that says that varies. I mean, the number of ranges that are in existence varies. At that particular time, there were 400 ranges in the state of Florida. They didn't say 400 ranges that only meet these criteria that's established by Mr. Vargas. Mr. Vargas's criteria, the judge pointed out to Mr. Cheshire, says under your theory, Mr. Cheshire, there would be no gun ranges. And Mr. Cheshire said, that's true. Because under his theory, there wouldn't. Because under his theory, if it can happen, it will happen. Under his theory, that even though there's no evidence that a bullet...
Well, as to the noise, I mean, that could be as to the bullet. It's a multifaceted nuisance complaint, correct? And so the noise part has to do with the adjacency of the land, I would think. It's not having to do with those who can't hear it.
Yeah, that is correct, Your Honor. But let's look at gun ranges. What do we know about gun ranges? They generate noise. What do we know about airports? They generate noise. What do we know about crushing plants? They generate noise.
Now, one interesting distinction between 823.16 and 793.33 is that 823.16 applies to sport shooting ranges, and 793.33 uses the phrase sports shooting and training ranges. And I believe appellant made the argument that the range here, it's not a pure sporting range, so it's not even entitled to the benefits of 823.16. Can you please address that?
Your Honor, the definition of what ranges are covered by the two are identical, except for 790 ranges include BB guns and air guns. I mean,
But it talks about for the purpose of similar types of sports shooting, and then in 793.3, the legislature seems to, indicate that there's sports shooting ranges and training ranges, and that those have different purposes. So your position is it doesn't matter that the legislature
my position is
had a
that,
broader class in 793.3 than?
right, is that what's the difference between sports shooting and training? I mean, you go to a range to shoot, to train, right? I mean, to.
Well, I guess here, and correct me if, I'm wrong, that the evidence or the allegations were that even if it started off as a sporting range, eventually it entered contracts with law enforcement agencies and the military to conduct training, and that goes into changing the nature of the range because the training occurs at night. Can you address any of those?
Well, first of all,
allegations?
the appellants have been very long on attorney arguments and attorney statements and very short on facts. They have no facts to support that. I mean, they made allegations that there's explosions and going on at the range and that things are getting blown up. They've made all sorts of allegations. I mean, Mr. Cheshire at one hearing said bullets are flying all over the Gartman's property when there's zero evidence that a bullet's ever left the range. So on that issue of what has there been military people and law enforcement people that have used the range? Yes, there have. Has the military entered some purchase orders to where they buy some time at the range? Yes, they have. Do they shoot in the same fashion that you or I would shoot at the range? Yes, they do. I mean, the ranges are designed for handguns. They're designed for rifles. The biggest rifles out there that are shot very rarely are, 50 caliber rifles, as Mr. Cheshire has pointed out. Those rifles can be fired by individuals and are by individuals. I myself have fired one. They're also fired by people who happen to be law enforcement officers and happen to be military officers. The nature of the range does not change by the fact that some people are out there in a uniform firing a gun just like the person next to them, not in a uniform, is firing a gun. It doesn't change the substance of the range's use.
So what would, subsection 5 contemplates that where there has not been a substantial change in the nature of the use of a range, that the nuisance action is barred, but if there has been a substantial change in the nature of the use of a range, then a nuisance action is permissible. What are they talking about there?
Actually, that section, Your Honor, is a grandfathered section. So, for example, when the range began, let's say that there is no noise ordinance. 5 years later, there is a noise ordinance. Okay. The range operators can say there's been no substantial change in the use of the range from the time that there was no noise ordinance to the time there is a noise ordinance. Therefore, the noise ordinance does not apply. It's a grandfather provision. When you look at the elements above it, what are the elements for that defense applying? The elements are that it's a permitted use, that it complies with any applicable noise ordinances, and that it only exempts it for noise. It doesn't exempt other nuisances. In fact, after the first summary judgment hearing, the 3 purported nuisances survived. Number 1 was, residue of gunpowder in the pool. That was alleged. Shaking of the house, that was alleged as being a result of activities at the range. And the third one was smell of gunpowder. All 3 of those, we had no duty as the defendants of burden of proof, but we took it upon ourselves. We said, let's look at experts who can scientifically measure those things. They can scientifically measure smell. Smell is caused by molecules. Molecules are carried by gunpowder. Gunpowder, smoke, we shot the dirtiest of all the gunpowder there in our test, which was black powder, and looked at the measured the smoke. Where did it fall down? Where did it precipitate? Well short of the Gartman's property. There's a green belt between the range and the Gartman's property that's, thickly wooded, and it never got beyond there. There were never a single photograph showing any smoke going onto the Gartman's property. I mean, they were there. They testified that they did everything from go to the governor's office to county commission meetings and everything else, and that they took a metal detector trying to look for bullets and couldn't find any. They put cheesecloth up to see if they could document any rounds coming from the range, and they never took a photograph of this smoke that supposedly was entering the property. So the judge found at the second summary judgment hearing, as Mr. Gartman conceded, he had no evidence as to the smoke entering his property, no residue from smoke, no evidence of residue of smoke, no evidence of vibrations that would affect his house. We hired a professional to look at the vibration issue. He tested the vibration issue. Mr. Cheshire and his associate tried to testify at trial. Well, there's other ways that the house could be shaken. I've worked in an oil and gas field, and I know that there's other ways that the house could be shaken, but there was no evidence on that. Zero, nada. So the court correctly granted summary judgment the first time, correctly granted summary judgment the second time. Judge Nordby, in our brief, we delineate the very strong public policy for ranges and the very strong public policy within the same statute also has a Protection of Farms Act, which also creates an affirmative defenses for farms
But is,
against nuisance actions.
strong public policy the same as overpowering public necessity, such that there must be no alternative method for meeting that public necessity? I mean, does it rise to that level?
Well, Judge, there's no guidance on that issue. Mr. Cheshire and I agree with one thing, is there's no
Well, I
cases.
think we have cases
that
from the
looked
Florida
at it.
Supreme Court where they dove into that, University of Miami via Charté, and other cases where there were, task forces, put together to address crises and medical malpractice premiums, and in the legislative bills adopting the recommendations from those task forces, they talk about there's a crisis, there's an overpowering public need for us to do something to lower premiums. I mean,
Well, you can have negative things that prompt a statute, and you can have positive things that prompt a statute. And the positive things was that we need ranges for
If you
people.
don't have gun ranges, you can't exercise your Second Amendment rights because you can't practice firing your gun.
You
Is
can't.
that the overriding public
That's the
policy?
overriding thing. You can't do the training that you need to do for
A
being a
gun is
hunter.
no good if you can't go to the range and practice shooting the gun.
And if ranges are going to be shut down because they make noise, you're not going to have ranges. Same reason for the Farm Protection Act. Farms generate some noxious odors, and they generate some noise. And if noxious odors and noise is going to cause the neighbors to be able to shut down farms, we're not going to have food. If noise from a range...
I mean, here, when your clients sought permitting, I assume, or development order from the county, I assume the appellants vigorously objected or fought that development order.
They did.
And the policymakers at the local level decided to permit the range.
That is correct. And to keep it permitted, and they find that there's no illegal activities. They have found no unsafe activities. The evidence indicated that there's range officers that promote safety. The evidence indicated that there's berms 50 feet high and over 25 feet thick that absorb any projectiles fired from the range. And the evidence is that this is typical of ranges. Ranges do not have concrete roofs over them. If somebody wants to intentionally hold a gun up and fire it at an angle to make it leave the range, they can do that. If someone wants to drive the wrong way on our interstates, they can do that. And they do sometimes. The fear of that something might happen means that anyone outside an airport should be able to close down the airport if they say, I fear that a plane is going to crash on its approach. Do planes sometimes crash on their approach? Yes.
Thank you,
But
Mr.
That doesn't
Fine.
close it down. Thank
If we
you.
could add 1 minute to Mr. Chester's rebuttal argument.
You were going to take a minute. I may take
You may take an additional minute.
Well, thank you. I appreciate that. I want to say this, a couple of things. First, 823-14. I had not introduced into this until last night when I got it as a supplemental authority. 823-14 is a smidgen different because the legislature passed that statute at a time when apparently they were told you may have some constitutional issue here, and they backed off of the same thing that apparently they did in 823-16. 14 has a period in which you, as a property owner, have the right to file an action and object to this farm if the farm's doing something which is objectionable. It carries over some of the same messages because it said if there is a change in the operation, then that changes things. It doesn't say a change from what, which is what makes 823-16 so very confusing. 823-16 is a change. I promise you, if you are the Gartmans and you're sitting on this property for 20 years.
Well, may I ask you if, under your argument, no property owner is ever going to want to be adjacent to a gun range, correct?
If you ask a property owner who's.
So your client's objected to the permitting of this range, correct?
Most gun ranges, most property owners would prefer not to be next door to a gun range.
Your client's objected to the permitting of this development order.
Yes, and the county permitted it with the requirement that it meet the gun range criteria, and then they ignored all of it and said, wait a minute, we don't have to do that because nobody's going to inspect us, and nobody ever did. Now, the point is made, can we shoot over a berm? Of course you can. A gun range is supposedly designed in a way that prevents the gun from being elevated to the point that it shoots over a berm. That's a part of the design structure. That's what Mr. Clark Vargas tells us. None of that stuff is on this gun range. I can elevate that gun. If you tell me for a moment that it won't go over a berm, you can build the berm 1,000 feet high, and I can shoot a gun over it. I would suggest to you all that everything we're talking about is a jury question. If we talk about reasonable use of a neighbor's property and what it's likely to do, that seems to me something that a jury has the right to decide. When you ask the question about a military range, is that different? I'm not real sure. For some reason, apparently the military, which has a range right there, decided there were regulations on their range that they didn't have when they come here, and that 793.3 says we're not concerned about those criteria. Our range has no restrictions at all. The military ranges do, so they use our range. It is, and as the judge pointed out, they use them 24 hours a day if that's what they choose to do.
Mr. Chester, can I give you 30 seconds to briefly conclude? Our clock has malfunctioned, I'm sorry, but maybe 30 seconds.
Let me say finally then that the court has asked a question about breathing the life of 790.333 into 823.16. If you're going to breathe life from hither to yon, you have to imply from 790.333 that it has the power to destroy the constitutional right one has to protect its property. I don't think anybody ever thought that you would imply the right to destroy a constitutional privilege. And that ignores that 790.333 says nothing in this act is intended to destroy the private right of an adjacent property owner. And if you're going to get part of it, you've about got to get it all, it seems to me. So we would request the court to reverse the trial court. Let us try this case. It has got to be tried.
Thank you, Mr. Chester. Mr. Fleming, thank you. That concludes our docket for today, so we are adjourned.
All rise.